The following program is brought to you by Stetson University College of Law, the National Clearinghouse for Science, Technology, and the Law, and was funded by the U.S. Department of Justice Bureau of Justice Assistance Capital Case Litigation Initiative.
Welcome to Forensic Psychology Essentials, the 9th in our series of webinars for the Bureau of Justice Assistance Capital Litigation Initiative, Crime Scene to Courtroom Forensics Training. This webinar was produced by the National Clearinghouse for Science, Technology, and the Law and the Office of Professional Education at Stetson. I'm your host, Dr. Dan Martell. I'm a forensic neuropsychologist. I practice all over the United States and have for the last 25 years. I do both criminal and civil litigation, but I've also consulted on quite a number of capital cases, and I know that many of you in the audience are interested in that topic, and we'll be covering that in some detail today. My practice specializes in issues of mental disorder, brain damage, and violent criminal behavior. I'm board certified by in forensic psychology by the American Board of Professional Psychology, and I'm a fellow of the American Academy of Forensic Psychology. I'm also a fellow of the American Academy of Forensic Sciences and had the pleasure to be the first psychologist to be president of that organization. There's some text here that I think I'm going to skip over, just talking about the various things I do. It covers a lot of forensic psychology, and I don't want to toot my horn for too much time. But my main interests are topics like waiver of Miranda rights, competency to stand trial, criminal responsibility and insanity evaluations, neuropsychological issues in all of those, as well as diminished capacities or diminished actualities and related mens rea defenses. I do quite a bit with mental retardation and mitigation in capital litigation. I was the Commonwealth of Virginia's expert in Atkins versus Virginia, and have done quite a bit of work on intellectual disability and the death penalty. Today's webinar will provide attorneys with insight into the specialized discipline of forensic psychology and its importance to the legal system. Our panelists will provide practical information for selecting a qualified forensic psychologist who can provide competent examination, thorough reports, and expert testimony. The expert panel will address emerging topics in forensic psychology, including cognitive bias, behavior genetics, and the specialized field of forensic neuropsychology. The webinar is also going to explore how forensic psychology examination outcomes and current research findings may impact legal proceedings. Joining me today on the panel is Dr. Randy Otto. Dr. Otto is a professor in the Department of Mental Health Law and Policy at the University of South Florida in Tampa, and has a practice that is limited to forensic psychological evaluation. He's board certified in forensic psychology and in clinical psychology by the American Board of Professional Psychology, and is licensed to practice psychology in Florida and Hawaii. His research and writing focuses on forensic psychological assessment. Currently, Dr. Otto serves on the editorial boards of a number of journals. He's a continuing education co-chair of the American Academy of Forensic Psychology, and he's the executive director of the American Board of Forensic Psychology. Dr. Otto has been nationally recognized for his work as a fellow of the American Psychological Association's Division of Psychology and Law. I want to talk a little bit about the chat feature that we'll be using today. While the webinar is in progress, you can chat with us at any time. Use the chat feature found on the right-hand side of your login screen. We will answer as many of your questions as possible. Please note that we may not get to all your questions while we're on the air. However, we will answer all the questions that you send to us and a Q&A document will be sent out to participants by email afterwards if we can't get to them during the program. This webinar is designed for both prosecutors and defense attorneys. Attendees who complete this webinar will be eligible for continuing legal education credits. The Stetson Office of Professional Education will work with each individual participant for reporting specifics. CLE applications will be made to Florida and other states per individual requests. Please email ope@law.stetson.edu. That's ope@law.stetson.edu for further information and state-specific requirements. All webinar materials can be found on the Education and Training page of our website. We encourage you to review the webinar's further reading list, which will include additional resources and the studies referred to in the PowerPoint presentation. At this point, it's my pleasure to introduce my colleague, Dr. Randy Otto, who is truly one of the most highly respected forensic psychologists in this country. I have been a student of his work and his scholarship throughout my career, and it's a pleasure for me to be here on the panel with him. One of the core concepts in our judicial system is the use of expert witnesses. And Dr. Otto, can you tell our folks a little bit about forensic psychology, how to find a good expert, what to look for, and what to expect?
Sure. Thank you, Dr. Martell. I'm happy to be here, and welcome to everyone. I look forward to spending a couple hours with Dr. Martell addressing a number of issues focused on forensic psychology generally, and also its use in a number of capital proceedings. We both encourage you to send us questions during the course of our presentations, and we'll answer them as best we can and as feasible. What I wanted to spend time talking about in an introductory manner was giving attendees a better understanding of how they might think about using forensic psychologists in their work in criminal litigation. What I'll spend some time talking about is what kinds of cases or what kinds of issues they might consider employing a forensic psychologist with, what makes for a good forensic psychologist in a particular case, how one might go about getting the best qualified psychologist in a criminal matter, what the attorney can do to maximize the likelihood that he or she gets a good examination, he or she gets a good evaluation that is most helpful to the attorney or to the court, describe what I believe to be the characteristics of a good examination, and then finally describe the characteristics of what I, as a forensic psychologist, believe to be good reports and good testimony. My goal during my time with you is to make you better consumers, to make you more knowledgeable about forensic psychologists and forensic psychology, what they can appropriately do, what they may not be able to do so well, how you can best use them, and skills you can employ to do the best job of selecting them, and then finally, how you can best consume their work once they do evaluate someone involved in a case with which you're working. So that's sort of what we'll try to cover during my time with you before I turn it over to Dr. Martell. Why involve a forensic psychologist, or what kinds of matters or what kinds of cases might use of a forensic psychologist be most appropriate? What I tell attorneys and judges is you might look to the assistance of a forensic psychologist when you're dealing with some kind of litigation, some kind of case that's involving a legal matter about which some aspects of the person's emotional, behavioral, or cognitive functioning is somehow relevant to a legal issue in dispute. In criminal proceedings, the arenas can be broad. Most obvious, I think, are issues of criminal competence. Person's understanding and ability to participate in the legal process, beginning at the time of arrest and detention and ending through sentencing. Most attorneys, of course, are familiar with issues of competence to proceed, or more commonly, competence to stand trial. But individuals who are involved in criminal proceedings, their competencies are at issue throughout the legal process. As I said, from the moment of arrest and interrogation all the way through criminal sentencing. Competence to understand and exercise one's constitutional right to avoid self-incrimination, more commonly called in some cases competence to exercise and waive Miranda rights. Competence to stand trial, work with counsel, understand and participate in criminal proceedings, although of course in reality the overwhelming number of criminal defendants don't ever move forward with the trial process, but rather enter into some kind of plea agreement, and as such, competence to enter into a plea agreement as well. Competence to be sentenced as well. Issues of criminal responsibility may also involve the work of a forensic psychologist, the claim here being there is some aspect of the defendant's emotional, behavioral, cognitive functioning that are relevant to understanding his functioning at and around the time of the alleged offenses that might go to some kind of mental state defense, whether that's something like insanity, criminal responsibility, diminished capacity, other kind of maybe more obscure or more exotic defenses, automatism, things like that. In addition, in criminal proceedings, attorneys might seek the input of psychologists to inform sentencing decisions, whether someone's capable of understanding and participating in the sentencing process, or whether there's some aspect of the convicted defendant's emotional, behavioral, or cognitive functioning that should be considered that are in some way relevant to the disposition. In each case, no matter what the legal issue is, the idea is that given his or her specialized knowledge about emotional, behavioral, and cognitive functioning, the psychologist can provide some information about the defendant that would not otherwise be known to or obvious to the judge, the attorney, or the jury that will allow them to make a more informed and presumably more accurate decision about this particular defendant as it goes to the particular legal issue in dispute. And that's what I want to spend some more time talking about as we go on. Now, what makes for a good forensic psychologist? I think it's a combination of both knowledge and skills. Knowledge of the legal system, right? A forensic psychologist should be have a reasonable understanding of the legal issue at hand, whether that's competence to exercise one's constitutional right to avoid self-incrimination, whether it's someone's ability to work, consult with counsel, and understand and participate in the criminal process, a knowledge of the legal system, of the law of the case at hand, whether it's criminal responsibility, criminal competence, or something else. The forensic psychologist has to have a rudimentary understanding of the rules of evidence to understand the vehicle by which what he learned, what she learned, the opinions he formed, the opinions she formed, how that kind of information is presented to an attorney, the judge, or jury. Also has to have a fundamental understanding of the rules of procedure that apply in a particular venue. Now, certainly, everyone agrees that the forensic psychologist need not have the level of knowledge that an attorney does, but at the same time has to have a basic understanding of the legal issue, of the legal system, and how it operates. But that's not enough. The forensic psychologist in a particular case has to have a well-developed understanding of the clinical matters at hand, or the clinical issues that are relevant. And the principle to be ascertained here, or the principle to be deduced, is that there's no one forensic psychologist who can do it all, just as there's no one attorney who can do it all. But even within the field of forensic psychology, forensic psychologists will have a number of specialties. For example, imagine a criminal case where there's some issue about a child witness who's alleged to have been victimized, and there's questions about the kinds of questioning that alleged child victim was subjected to, and whether that was leading in any way, and maybe that questioning some way tainted the representation that alleged child victim is offering. The forensic psychologist who can provide some observations about this particular child's ability, about the quality of the questioning that the child was subjected to, maybe by a law enforcement officer or maybe by a mental health professional working on behalf of law enforcement. That's a particular set of knowledge. That's a particular set of skills. In that case, you want a psychologist quite knowledgeable about developmental issues, about child questioning, about the best ways to go about asking children and questioning children and interacting with young children when you're trying to gather information from them. Contrast that with a case involving a criminal defendant who's who's facing some kinds of serious charges, and it's been established that the defendant has some kind of developmental disorder, maybe in the autism spectrum. The question is how that defendant's particular developmental disabilities, that defendant's particular developmental limitations might affect either his understanding of and ability to participate in the legal process and work with counsel, or maybe there's additional questions about whether the limitations associated with those developmental disabilities affected his understanding of his behavior at and around the time of the offense. In that case, the lawyer is going to want a forensic psychologist with particular knowledge around autism spectrum disorders, and how the kinds of limitations that typically manifest among people with autism spectrum disorders, how that might go towards limiting his ability to understand and participate in the legal process if it's an issue of criminal competencies, his ability to work with counsel in a criminal competencies questions, or his understanding of what is appropriate and what is not appropriate, what is wrong or what is not wrong if it comes to an issue of criminal responsibility. And then finally, of course, the forensic psychologist should have a well-developed understanding about how working in the legal system is different from what most psychologists and what most mental health professionals are trained to do, which is really work therapeutically with people. The overwhelming majority of psychologists, psychiatrists, social workers, and other mental health professionals, their training is really devoted to matters therapeutic, understanding people's emotional, behavioral, and cognitive functioning, identifying limitations, impairments, and responding to and working with them in a therapeutic way. That's very different from forensic work, from forensic activities, which the issue or which the task is to focus on someone's emotional, behavioral, or cognitive functioning at a particular point in time and educate a judge, an attorney, or a jury about how some aspects of that person's emotional, behavioral, and cognitive functioning are relevant to the legal issue, the legal issues in dispute. So that's kind of the knowledge base that the forensic psychologist should have coming in. But that's not enough, right? The forensic psychologist is going to have particular skills, behavioral abilities, and most obvious among them, I think, are the skills of assessment and presenting one's work and opinions. Almost always when forensic psychologists are involved in matters, it's for purposes of evaluation. kind of springboarding from what I said earlier, assessing some aspects of a person's emotional, behavioral, or cognitive functioning at a particular point in time, and helping a judge, juries, or attorneys better understanding how their functioning impacted their abilities in some way or are impacting their abilities in some way. So clearly, skills to assess emotional, behavioral, and cognitive functioning are critical. But that's not enough, right? The psychologist must be able to effectively and efficiently communicate to an attorney, to a judge, to a juror, who he or she is, what he or she did, the information he or she gained, and the opinions he or she formed as a result of that evaluation. You can have the most qualified psychologist, who is the world's leading authority on matters of developmental disabilities, on issues of dementia and how those kinds of limitations might affect a criminal defendant's functioning. If he or she can't efficiently and effectively communicate to an attorney, to a judge, or to a juror what he or she did, what he or she learned, and the opinions he or she formed, then that person is not in any way being helpful, since conceptually I think it makes most sense to think about an expert witness as an educator, right? A particularly complicated issue, some aspect of someone's emotional or behavioral cognitive functioning, that the audience, that an attorney, a judge, or juror is not particularly knowledgeable about. And the idea is that the psychologist's expertise can help the judge, the juror, or the attorneys better understand the matter so they can make more informed decisions. But if that psychologist can't communicate what he or she did, what he or she learned, and the opinions he or she formed, then they're not going to be persuasive. I'm sure everyone in the audience can look back to their experience in law school. They can think about sitting in a law lecture where they were the student of a renowned legal mind who was a leading authority in a particular area, but little was learned. Because why? Because the professor wasn't, in an effective way, able to communicate what he or she knew. So not only is it knowledge, not only is it skills, but it's the ability to share the information gathered, share the opinions formed by way of either a written report and or proffered testimony. So we hopefully have some understanding of what makes for a good psychologist, a good forensic psychologist. Now maybe the next step is how to go about finding one. I think most attorneys, at least in my experience, at least make some effort to ask their colleagues, someone else in the prosecutor's office, someone else in the public defender's office. I'm looking for a psychologist. This is the issue, whether it's criminal competence, criminal responsibility. Do you have any experience or do you have any knowledge? And I think that kind of word-of-mouth representation and that word-of-mouth search is just a fine start. But I would stress that I believe it's only a start. Once you have the name, once you've identified the name of a psychologist or psychologist by either word of mouth or maybe some kind of internet search or review of the literature, I encourage you to interview the psychologist. Spend some time talking to the psychologist about who he or she is, what he or she has done, his or her experience in the particular matter at hand. I'll tell you my own experience is that I'm surprised about the frequency with which I'm contacted by attorneys. Attorneys contact me by phone. They typically initiate our conversation with some explanation of how they got my name, oftentimes from an attorney colleague, and they go right into a discussion of the case at hand, and I don't think they take enough time kind of ascertaining for themselves what my qualifications are, what my knowledge is, and what my skills are. What I would recommend to those of you in the audience is to spend some time with a psychologist who you've identified somehow. Query the psychologist about his knowledge of the legal issue and knowledge of the law. If this is a diminished capacity case, talk to him or her about his understanding of diminished capacity mens rea defenses in your jurisdiction. If this is an issue about competence to waive counsel and represent himself or represent herself, talk to the psychologist about his understanding of kind of key legal decisions in this area and the kinds of things that the psychologist believes are appropriate to consider to inform a judge's decision about whether a particular defendant is able to make a rational, self-interested decision about firing attorney and representing himself in some kind of criminal proceeding. Particularly if the defendant at issue is suffering from maybe a less common kind of mental disorder, the attorney might do well to spend some time talking with the psychologist about his or her experience interacting with people with these particular kinds of impairments. So for example, if this is a defendant for whom an intellectual disability is well established, and the question from the attorney's perspective is whether this intellectual disability is functioning in such a way that it limits the defendant's ability to understand and participate in the legal process, you might spend some time talking with a psychologist about his experience working with, evaluating individuals with intellectual disabilities. If this is some kind of criminal responsibility matter, it's a mental state defense case where maybe the defendant at and around the time of the offense is alleged to have been experiencing some kind of dementia, some kind of brain impairment. The attorney might want to spend some time talking with the psychologist regarding his experience evaluating, treating, or otherwise working with persons with particular kinds of dementias. I think it also makes sense to talk to the psychologist about the approach that he or she would employ if hired by you in a particular case. If the issue is a defendant with an intellectual disability and whether that intellectual disability functions in such a way that it limits the defendant's ability to understand and participate in the legal process to work with counsel, it's an issue of criminal responsibility. How would the psychologist go about evaluating that? What kinds of information would the psychologist see? Now, I don't expect the attorney will have some kind of sophisticated understanding of any particular tests that a psychologist would employ, maybe in a particular case. But what I would hope is this, is that as the psychologist makes an attempt to answer the attorney's questions, the psychologist will be able to help the attorney understand how what he or she proposes makes sense and how that's a reasonable way to go about assessing an intellectually disabled defendant's ability to understand and participate in the legal process. And what I would say is if during this conversation, the forensic psychologist can't help you understand how his or her proposed evaluation approach is a reasonable one and a reasonable way to go about evaluating these matters, I don't know how he or she is going to convince a judge that that was a reasonable approach. Here you also get to assess, you also get to test the psychologist's ability to educate you as a consumer of his or her work, to educate the judge as a consumer of his or her work, or in some matters, educate the jury. If the psychologist can't help you understand what he or she proposes to do, if he or she can't talk about it in a way that you understand, then that's not the right psychologist. And then finally, what I would say is talk to the psychologist about his or her experience in court and in conducting these kinds of evaluations specifically. Has he never done such an evaluation before? Has he done these evaluations routinely? Has he ever seen a defendant with this particular kind of challenge or problem before? Or would this be the first such experience? Once in addition to doing that, you might contemplate asking the psychologist for a report summarizing a prior evaluation. Obviously, the report should be de-identified and sanitized and protected in such a way to protect the identity of the particular defendant evaluated, but I think there's nothing wrong with asking the psychologist for a representation, for an example of his or her work. Not only does this give you insight into the psychologist evaluation approach, it also gives you some insight into his or her ability to write. It also gives you some insight into his or her ability to discomplicate these complicated matters. In every case an expert is sought, the attorney's goal is to seek assistance discomplicating a complicated matter. When you're looking to a psychologist, it's a complicated matter regarding someone's emotional, behavioral, cognitive functioning. Read the report that's provided. And what I say is after you get to the end of the report, you've given the report due attention. If you can't understand what the psychologist did, what the psychologist learned, the opinions the psychologist formed, and how he or she got to the opinions, he or she has not done his or her job. The job is to educate. The job is to discomplicate. And in terms of reviewing a report, you may well get some real good insight into that psychologist's ability to do his or her job. Other kinds of activities you certainly want to look to is ensure that the psychologist is licensed. Licensure is a state function, and much like attorneys need to be licensed by way of bar membership at the state level, so too do psychologists need to be licensed by way of licensure as a psychologist. A psychologist should be able to provide that quickly by way of review of a CV or resume, and more and more licensure status can easily be ascertained by way of an internet search. My understanding is most, if not all states, have mechanisms in place where you can quickly do an internet search. Using the internet, you can get on the state health department licensure, maybe, health department site, and ascertain the licensure status of any kind of healthcare professional, including whether there have been any actions taken against the license of that psychologist or other healthcare professional. In addition to licensure, I think you might want to consider board certification. Board certification for all healthcare professions is voluntary, but it does represent further certification of the healthcare professionals' expertise, competence, and credentials. Currently, psychologists can be board certified in one of 15 different specialties. Among the most likely board certifications that might come up among psychologists involved in the legal process, board certification in forensic psychology, board certification in clinical psychology, board certification in clinical neuropsychology, are all specialties or subspecialties where board certification is granted by the American Board of Professional Psychology. As I said, a total of 15 psychology specialties. There's availability for board certification across those different specialties, including forensic psychology. And I've got on the screen here the websites for a couple of the relevant boards. The American Board of Professional Psychology kind of functions as an organizing entity of the 15 member boards. The American Board of Forensic Psychology, one of the 15 member boards. Attorneys can use these websites to identify relevant board certified psychologists. They can also use these websites to check on the board certification status of a particular licensed psychologist.
I got a question for you, Randy.
Sure.
If an attorney is looking for a psychologist in a particular area and they go on to the American Board of Forensic Psychology website,
right,
can they find, if they need someone who's a specialist in juvenile psychology or in divorce mediation, can they find experts that way?
Yeah, the American Board of Forensic Psychology website allows for identification of forensic psychologists in a number of ways. One is geographically, so you can search by state, and another is by specialty area. So it could be something like child witnesses, it could be juvenile justice or juvenile delinquency, it could be criminal competencies or something like that. So both those search functions are available.
Great,
Okay.
thank you.
Also, you can search by name. All right. I think I said earlier that I've sometimes been surprised by the lack of effort that attorneys have sometimes made with me in terms of vetting me and taking the time to ensure that I'm appropriately qualified, that I might be a good fit for his or her particular case. Because as I said, there's no one forensic psychologist that can do it all. And I have a slide up here on the screen that demonstrates the potential bad outcomes when appropriate vetting is not done. This was a screen grab that we did from a local news outlet here in the Tampa Bay area. It doesn't involve a mental health professional of any type, but it does make the point. What you're seeing is a screen grab, and you can go to the web page if you want. But this is a screen grab detailing the arrest of a man who did testify in a number of criminal proceedings. He had been retained by the defense, and I think the common denominator in all of these cases were that the defendants had been charged with child sex offenses and using computers in some ways. This particular individual is accused of having misrepresented his credentials, including academic degrees and things like that. He actually did end up testifying in a number of criminal cases, and then it was later discovered that none of the degrees he claimed, it was alleged that none of the university degrees he alleged to have had in computer science and related matters actually existed, thereby obviously raising questions about about his expertise, as well as the testimony that he offered in those particular cases. So maybe just kind of an example of how bad it can go without appropriate vetting, without appropriate due diligence.
So we have a question that's come in.
Okay.
The questioner is curious, can you find disciplinary actions involving psychologists on any of the websites that you mentioned?
Yeah, so I think this is referencing my comment that most, if not all, states allow you to look at the licensure status of a particular person by way of getting onto a particular website, the Department of Health, or something like that. I can't speak for all jurisdictions. There's 50 jurisdictions. I can speak, however, to my experience, and certainly in the state of Florida, not only can you determine whether someone has been licensed, you can determine whether the relevant board, the Board of Medicine, the Board of Psychology, the Board of Nursing, whether they have taken action against that person's license. Yes. So I know that's the case in Florida because of personal experience, just my experience in looking at the board functioning, and I'm going to assume that that's the case in many jurisdictions as well.
It's certainly the case in California and other places that I've looked.
Okay.
Yeah.
All right. Very good. So let's assume the attorney has done his or her due diligence and is is ready to begin the evaluation process. How to get a good examination? Well, first, get a qualified psychologist, but we've already covered that. Step number 2. Be as specific as possible with your referral question or your referral questions. That directly impacts the helpfulness of the information that the psychologist obtains and provides to counsel. Incredibly unhelpful is referral to a psychologist with, give me a psychological evaluation, or what I need is a psychological evaluation. Much better is, this is the defendant and this is the issue at hand. There's questions about his intellectual functioning, and whether his intellectual functioning prohibits him from working with me and making good decisions about his case and understanding and participating in the legal process. This is a question about his competence to proceed, and I want to know if he's experiencing any kinds of impairments that limit his ability to understand and participate. The more focused you can be in providing a question or multiple questions, doesn't have to be limited to a particular question, but the more focused questions, the more focused the evaluation will be, and the more helpful the product will be in terms of a written report, in terms of proffered testimony. I think it's also helpful if attorneys can go about obtaining and providing collateral information that they believe will be important, that they believe may be relevant to the psychologist's evaluation, the psychologist forming relevant opinions. Now, I fully acknowledge that a particular attorney in a particular case might not know what is relevant. It's not obvious to the attorney that school records would go a long way to helping the psychologist understand or ascertain whether there is a demonstrated history of attention deficit disorder or intellectual disability. So in this case, I'm not asking attorneys to be mental health professionals. Insofar as acknowledge the attorneys might not always know what the most relevant records will be, but in some cases you may well know, and to the degree that you think you can do a good job of ascertaining the relevant records, whether it's a record of prior mental health treatment, school records, the arrest report, maybe a transcript of a plea hearing, whatever it might be, try to get that up front and provide it affirmatively to the psychologist. Now, keep in mind, once you provide the psychologist with the information that you believe is relevant, the good psychologist is going to say thank you, and there's a few additional documents that I need that you haven't provided me. Maybe they're not available, maybe there are no such documents, or maybe you didn't know that they were relevant. But to the degree that you can, as an attorney, I think you should make efforts to gather those documents and provide them affirmatively to the psychologist who's going to be evaluating the litigant in a particular case. Consider sitting in or recording the examination conducted by the expert that you retain or conducted by the expert that opposing counsel retains. A few caveats here. One is the law may or may not permit this. For example, in Florida, where I predominantly practice, in criminal proceedings, the law gives a fair amount of leeway to attorneys who are interested in or have an interest in sitting in on particular kinds of criminal evaluations, criminal competence evaluations, and criminal responsibility evaluations. So the law may or may not permit it, and obviously if the law does not permit it, then this is something that you can't pursue. Even if the law does permit it, there may be resistance from the psychologist in a particular case, and particularly when the psychologist is administering testing. There's a discussion around these issues that goes well beyond the time we have here today, but psychologists might express a variety of concerns regarding standardization of the testing process, regarding test security and matters like that. And in some cases, you might get some resistance around those matters, but in some cases, you may not. If you experience resistance, maybe there's some kind of mutually agreeable approach that you can employ, some kind of approach that you can live with and that the examining psychologist can live with. And note that I point in that you might consider sitting in on the examination. An alternative is to record the examination. A great way to document the examination, or maybe even the expert that you retain sitting in on an evaluation that's being conducted by another expert. Now, let's assume the evaluation has been conducted. What I'd like to do is spend some time talking about characteristics of good evaluations, reports, and testimony, maybe to use as a checklist in the future. Good evaluations are focused on the psycholegal issue in dispute. The attorney affirmatively discloses, affirmatively identifies for the psychologist up front what the legal issue is. And the focus of the evaluation is that legal issue. Irrelevant matters are not the focus of the evaluation. Irrelevant matters are not addressed in the report. Irrelevant matters are not addressed in the testimony, if testimony is offered. A good evaluation includes multiple sources of information. A good evaluation doesn't simply consider the self-report of the examinee or the litigant. If it's a criminal matter, there's significant issues at stake. It would be naive to assume that everything the defendant presents is 100% accurate. Furthermore, in many cases, relevant information may not be held by the defendant. If some understanding of the defendant's early history is relevant, his early childhood, whether he experienced some kind of significant head injury or other kinds of illness or impairment during infancy or early childhood, that information simply might not be held by the defendant as a result of his or her age at the time of the incident in question. So a good forensic evaluation simply doesn't rely solely on the self-report of the individual who's the subject of the evaluation, and that's one real important way that you might distinguish a psychologist's work with someone in a forensic context different from when they're working with them therapeutically. There are literally thousands of psychological tests. Most of those tests address issues, they address matters that are not particularly relevant to what a lawyer or a judge or a jury is concerned about or cares about when it comes to a particular criminal defendant. So although there's many thousands of tests that a psychologist might use, it's her responsibility to identify tests and use tests only if they're somehow relevant to assessing some aspect of the person's functioning or some piece of the legal issue or the psycholegal issue in dispute.
I got a question for you.
Yes.
It's just come in over the wire.
Okay.
It goes back to your previous point about including multiple sources of information. And the person is asking, will all the records used by the psychologist in a given case be discoverable by the other side?
Okay. So I see the question on the screen. Will all the records used by the psychologist in a given case be discoverable by the defense and plaintiffs? So I'm going to expand my comment to include criminal and civil matters. I'm going to preface this by saying, 1, I'm not an attorney. 2, this involves some pretty complicated issues around evidence and also around privilege. In some cases, attorney-client privilege may prevent opposing counsel from accessing the psychologist's involvement, much less records that he or she relied on. In many cases where the psychologist has offered a report, has testified, everything and anything the psychologist has been provided and considered is going to be accessible. But I know enough as a psychologist and non-lawyer to know that that is a very, very complicated question involving matters of privilege and evidence. And if you have any, if you want to help chime in and help me with that or have any thoughts, I'd be happy to hear them, Dan.
I'd say my view is the conservative thing to do is to assume that anything you give your expert is going to be discoverable. I think that's the conservative path. Now, that there may be room to fight about it, lawyers can fight about it later, but I think up front it's safe to assume that anything your expert is relying on is discoverable, because then the expert on the other side wants to rely on the same universe of information. So.
Okay. All right. Good question. Thank you.
I think you had 1 point left on your last slide. Oh,
yeah.
No, this is it.
Right.
We're good. Yeah.
Another point, and actually Dr. Martell is going to be picking up on this a little later, good evaluations, they involve an approach where the psychologist seeks all relevant data and not simply the data that confirm the theory of the case that the retaining attorney might be presenting, but all relevant data, including data that might be inconsistent with the retaining attorney's perspective, including data that might be inconsistent with or disconfirm hypotheses or early thoughts or ideas that the psychologist is forming as he or she is involved in the case. But what the evaluation should not be is simply an attempt to gather data that confirms what the attorney once argued or what the psychologist may believe. Good reports and testimony describe when and where the evaluation took place. Good evaluations, good reports and testimony disclose how long the examiner spent with the examinee. Think about it. Let's say this is an issue of a condemned inmate's capacity to understand the sentence that's about to be imposed, the death sentence, right? Understanding of the death penalty and competence to be executed. A more serious question I can't imagine being addressed by a court or by a psychologist. Does it matter to you whether the psychologist spent 20 minutes with the defendant or 2 hours and 20 minutes with the defendant? It matters to me if I'm trying to draw some conclusions about the quality of the psychologist's work. That's not to be said that there's a clear relationship or a direct relationship between how much time was spent with conducting a particular examination and the quality of that evaluation, but it is a relevant piece of information. We did some research here in Florida looking at psychological and psychiatric evaluations, summarizing work with criminal defendants. The data indicated that in 18% of the reports did the examiners affirmatively disclose how much time they spent interacting with the criminal defendant.
Only 18%?
82% of the cases, there was no reference to how much time was spent with the criminal defendant, which again, I think is critical, an important piece of information with respect to drawing some conclusions about the thoroughness of the evaluation, although it's clearly not the be-all and end-all. Good reports, good testimony, they identify all sources of information provided, obtained, and considered. The psychologist affirmatively discloses what information she sought, what information he or she was provided, what information he or she gathered, so that the consumer, so that the attorney, so that the judge, so that the jury can make his or her own decision as to the comprehensiveness of the psychologist's database. Are there any obvious things missing? Well, wait a minute. The psychologist offered an opinion about the defendant's mental state at the time of the offense, but he didn't review the arrest report. He didn't read the statements that were authored by the crime witnesses and the crime victims, who presumably could offer some helpful insights with respect to the defendant's emotional and behavioral and cognitive functioning at the time of the offense. I'm going to have questions about the validity of the psychologist's opinion if those data were available, but were somehow, for some reason, not provided or not accessed. Good reports and testimony only include relevant data. They don't include data that are irrelevant, that might distract the reader, that might distract the audience, that might distract the listener from the important information. They distinguish for any important facts that are offered. They identify the source of information. Perhaps it's critical that this defendant had previously had a diagnosis of schizophrenia. Where did that come from? Was that the defendant's representation? Was the psychologist provided with records chronicling 3 years of treatment for schizophrenia? Was that something the defendant's mother offered in an interview? You can see how, in some cases, the source of the proffered fact is relevant to drawing some conclusions about the legitimacy of the proffered fact. Really important for important facts. Good reports, good testimony richly describes relevant aspects of the person's emotional, behavioral, and cognitive functioning, as well as their history. Good reports, good testimony richly describe how any of that information is relevant to the legal issue that's in dispute. Good reports, good testimony, they either exclude medical jargon, they exclude mental health jargon, or they explain it. What I say is that if an attorney reads a report, if an attorney listens to testimony, and there's concepts or words presented that the attorney doesn't understand, the expert hasn't done his job. The expert hasn't done her job, which is to discomplicate complicated matters. Good reports, good testimony include only expert opinions. Expert witnesses provide expert opinions, which are opinions based on specialized knowledge, specialized training, specialized experience. Good reports, testimony provide the factual basis for any opinions that are offered so that the consumer, the judge, juror, or attorney can draw their own conclusions about the validity of the opinions. As I said earlier, they provide data that are contrary to or inconsistent with the opinions that can disconfirm, but explain why their opinions are right nonetheless. And good reports, good testimony make explicit the psychologist's reasoning and the psychologist's logic, so that you can sort of follow along, you can understand how the psychologist got to where he or she got. And then finally, for your review, I've just provided a report checklist that you might provide in a particular case. This really is kind of a review of a number of matters that I included in the past few slides, but maybe kind of a handy form to print to facilitate your review about the adequacy of a report offered by an expert psychologist or any other expert for that matter, or testimony offered by a psychologist or any other expert for that matter. So I think right now we don't have any pending questions.
We don't.
So with that, Dr. Martell, I'm going to turn it over to you.
Do we have any questions from the audience for Dr. Otto before I have my turn? Wait a beat for people to type. And seeing none, and we'll move on to my part of this talk. So I'm going to cover 3 different topics that I think are currently at the cutting edge of capital litigation in terms of psychological science, and frankly, all of forensic science as to the first topic. My first slide. So I'll be talking about 3 topics today. The first is cognitive bias, by which I mean, in the best case, these are subconscious biases that affect the way people make decisions. There's outright bias, which is an ethical problem for psychologists. If they're slanting their opinions on purpose to assist their client, that's not good ethical practice. Cognitive bias is something different. It's something that occurs in a less blatant fashion, but that affects all of our decision making, and particularly so in a forensic case. And this is a very hot topic in all the forensic sciences, and we'll spend a little time learning about that and what's involved and what attorneys can do to help their experts overcome it, or at least try to minimize it. The second topic I'll be discussing is behavior genetics and how genes are becoming an important issue in determining, maybe not so much in the case in chief, but in penalty phase and in post-conviction relief act litigation, uncovering topics that may not have been considered in the case. And then the final topic is neurobehavioral imaging. Brain scans are nothing new in capital litigation, but there is some new science that I want to touch on today that goes to the nexus of brain structure, brain function, and moral decision making, which adds a new level of interest and complexity in a situation where life and death decisions are being made. So those are the 3 topics we're going to cover. These will be 3 mini lectures this afternoon. So let's talk a little bit about cognitive bias. Cognitive bias is a mistake in reasoning, evaluating, remembering, or other cognitive processes, often occurring as a result of holding on to one's own preferences and beliefs regardless of contrary information. You go with what you know or what you think instead of doing a more careful analysis of the entire universe of what's before you. Psychologists study cognitive biases as they relate to memory, reasoning, and decision-making. So here's some forensic examples of cognitive bias. The first one, and perhaps the most significant one here, is something called allegiance effects. And this is like pledging allegiance to the attorney that hired you in the case. Formation of opinions in favor of the retaining party rather than an objective assessment of available evidence. Anytime I'm hired, any psychologist is hired in a forensic case, much less in a death penalty case, there's enormous pressures. Your personal beliefs about the death penalty, for example, are difficult to put aside and may impact the way you think about a case and the opinions that you reach. Your desire to be liked by your client and come to an opinion that helps your client in their case may also come into play here, and there's pressure for that. The desire to get hired again in another case, a financial incentive, may come into play. These are all things that play into allegiance effects. I'd like to talk a little bit about a psychologist named Dan Murray. He's the head of forensic psychology at the University of Virginia's Institute of Law, Psychiatry, and Public Policy. He's a psychologist, and he did a fascinating study where they found 100 psychologists, brought them in for 2 days of training on the use of a test called the psychopathy checklist. For those of you that haven't heard about this, first of all, psychopathy is a way of measuring a personality trait. It's similar to antisocial personality disorder, but psychopaths are the cream at the top of the antisocial personality milk bottle. They're the worst of the worst in terms of lack of empathy, lack of remorse for the things that they do, having self-serving motivations, and doing bad things to other people. So the psychopathy checklist was developed by a psychologist named Robert Hare. So you'll sometimes hear it referred to as the Hare psychopathy checklist. Defense attorneys tend not to like it because it might make their client look bad. Prosecutors tend to love it because it might make the defendant look bad. But at the end of the day, as a psychologist, if this test is going to be used, it's particularly important that the data, that the result of the test be accurate. So what Dr. Murray did was take these 100 psychologists and train them all up to criteria in a 2-day workshop, and then he brought them back about 4 days later and asked each psychologist to score 4 psychopathy checklists based on record review, the file in the case, and a report of an interview with the defendant. What wasn't known was half of those psychologists were told that they were being hired by a prosecutor, and half of them were told they were being hired by defense. What do you think happened? The psychologists that were hired by the prosecutor tended to rate the cases as more psychopathic, and the psychologists that were hired by, or thought they were hired by the defense attorney, tended to rate their cases as less psychopathic. Now, the absolute difference here was small. We're talking 2 or 3 points difference between the two groups. But what this did was provide a wake-up call to psychologists that our data is vulnerable to these effects. And psychopathy often is an issue in capital litigation and in all forensic criminal cases, to the extent that there's an issue about future dangerousness, because it's one of the best predictors of future violent behavior. And for that matter, just personality and character. I'm checking for questions on the screen over here. Okay. All right, so some other examples of cognitive bias. The next one is anchoring or primacy bias. And this is information that's received at the outset of a case that may lead to initial ideas and formulations that are later difficult to abandon. So when an attorney calls me and says, "Doc, I got the craziest guy I've ever seen. You got to come figure this out, what's wrong with him," right away, that attorney's poisoning the well. Because now I'm thinking, well, this guy's terribly crazy. I need to go in there and solve this problem, as opposed to saying, "I've got a case that needs competency evaluation. Can you come do the testing?" The second type of bias here is confirmatory bias. Once you have that anchor or that primacy, then you focus on evidence that supports that position rather than disconfirms that hypothesis. So your scope of vision becomes skewed, looking for things that will support the opinion that your client wants you to achieve. There's also something called fundamental attribution error. These are a lot of funky psychology words that I will make an effort to discomplicate. So this has to do with attributing more weight to dispositional qualities, characteristics of the person, that they're mentally ill, that they're intellectually disabled, that they were abused as a child, rather than looking at the situational circumstances when considering the reason for someone's behavior. So much of our behavior is determined by the circumstance that we find ourselves in, regardless of whatever disposition we may bring to that situation. So the fundamental attribution error is ignoring the situational circumstances in favor of disposition or character or qualities of the defendant. The final one I'll talk about this morning or this afternoon is a diagnosis momentum. And this is the thought that assigning a particular diagnosis without adequate evidence to start with can subsequently, like a stone rolling down the hill or a snowball, gather momentum over time to the point where it seems reasonable and accurate when in fact it may be not accurate and not reasonable. And this, at the end of the day, goes to overconfidence. Overconfidence in your opinion, I've seen this 1,000 times, I know what this is, leads to insufficient data collection and synthesizing of information prematurely.
Dr. Martell, I have a question. These are clearly important issues, and it's obvious to me as a forensic psychologist how they can affect the psychologist's judgment. For attorneys in the audience, is there a reason to believe that it's simply psychologists and other mental health professionals that they have to be concerned about with respect to these matters, or might it be other experts as well?
It's every expert that they encounter. There have been studies like the Dan Murray study of people who do bench science, like toxicologists. And they'll be contaminated. A toxicologist doesn't really need to know anything about a case. What they need to do is get a blood sample and put it in the machine and decide, has this guy got cocaine in his system or does he not? And what will happen is the prosecutor calls and say, "Oh, I've got a murder case, it's horrible, he killed a baby, he did all these terrible things." And this pollutes even a bench scientist to the point where different results will come out. I don't understand how, but it can happen across all forensic experts. So this is a systemic problem. It's a public policy problem in forensic science. And I think that we're just beginning to think about ways to mitigate this and to change the way we go about doing forensic science in order to minimize these kinds of cognitive biases. It's a very hot topic. Let me just go back here. Okay, I talked about overconfidence. So what do mental health experts think about this? And before I even say that, to just kind of dovetail on Randy's question about why should attorneys care about this? And at the end of the day, to me, what makes you care about it is the fact that it's going to make your expert more credible. Your expert's opinions are going to carry more weight when they have done the work the right way, when effort has been taken to minimize cognitive bias, when they've looked at things that both support and refute the opinion that they're going to offer, as Randy pointed to earlier. This is the payoff for the attorney, is an expert who is unimpeachable, an expert who has credibility with the trier of fact. And that's the end product that makes this important for all of us to consider. So let's talk about Patty Zapp's study. Patty Zapp is another forensic psychologist, and because this is such a hot topic, she went out and studied 1,099 forensic mental health professionals. They were psychologists, psychiatrists, psychiatric social workers, and most evaluators expressed a concern about cognitive bias, but they also held the incorrect view that mere willpower was enough to reduce the bias. Once I know about it, well, I'll just try hard to not be biased. The other thing they found was evidence for what's been described as a bias blind spot, where evaluators recognize bias in their peers' judgment. Oh, Randy makes biased decisions all the time, but not me. I don't make those kind of decisions. It's always the other guy who's biased, and I'm better. So let's talk a little bit about countermeasures. One of the things the Zapp study did was look at bias training. And at this point in time, this is a very popular topic, as exemplified by the fact I'm talking to you about it today. The Zapp study evaluators with training in bias held beliefs suggesting that an increased awareness and understanding could help ameliorate the impact of potential cognitive bias. Now, this is encouraging, and it's a good first step, but it remains to be seen whether mere knowledge translates into improved performance for the reasons we just spoke about, where you may perceive that blind spot, that other people do it, but I don't. My stuff doesn't stink because I know about bias and I try to control it. So what can attorneys do when hiring a psychologist or a psychiatrist or any forensic expert to minimize allegiance effects? The best thing you can do is clearly state at the outset of a professional relationship your expectation that the expert's conclusions are going to be objective and based on all the data available, even if it might not support your position. Now, this is often difficult to do, but again, if we go back to the end game and the goal that you want when you have that expert on the stand for you in court, you want them to be unimpeachable. You want them to have integrity. And by doing this, you can increase the chances of that. Minimize anchoring and primacy bias. Don't poison the well. I've had prosecutors tell me, as I'm about to walk in and evaluate the defendant, and they'll say, now, you know, I don't want any mitigation in this case. So what's the message to me as a supposedly independent expert walking in to do an evaluation in a capital case, and the prosecutor is telling me, don't go in there and bring back any mitigation. That is poisoning the well. And frankly, it's not just prosecutors. Defense attorneys are guilty of this kind of thing as well. So you want to be careful in what you provide to your expert. Too often I've seen cases where they give me a subset of the records and withhold evidence that maybe they don't want me to see, they don't want to consider, they don't want to shine a light on. This is never a good idea, because what happens is eventually the other side is going to uncover that data. They're going to hold it up in court and say, did you consider this? And I have to say, no, I didn't. I was never given that. And so that wasn't part of my formulation. Well, does this change your opinion? Well, yes, it does. So this is never a good idea. So you want to always provide facts that both support your opinion, but also support the facts the opposing side is likely going to argue. When I take a case, I ask for all the discovery in the matter, even though it might be 3 bankers' boxes full of paper. I'm better off that way than to have someone else select what it is I'm going to consider in reaching my opinion. Another thing you can do is avoid lengthy pre-evaluation interviews with your experts. Give them the facts, give them the referral questions that Randy talked about, and let them do their work. Talk to them afterwards and see if their opinions are helpful to your case. But don't spend a whole lot of time in pre-evaluation interviews, which may tend to shape or distort the way the expert is going to see the case through your lens.
Dan, when you mentioned that, would you distinguish between the attorney spending a fair amount of time with you independent of case matters, for example, ascertaining your experience, your qualifications, kind of how you go about doing this work, without a discussion of any specifics involved in this particular case?
Absolutely. That's the difference between vetting the expert and actually hiring them and using them in your case. Okay. I completely agree with Randy's points that people should vet their experts. You want to know. It's a great idea to see a prior report so you know how the expert communicates. It's a great idea to talk to them about the legal standard and how often have they evaluated competency or ability to waive Miranda rights. What do they know about it? Do they talk about it with intelligence and with experience? Because that'll be translated to the jury when they come to court. So those are great points, and I see that as it's sort of a two-stage process. One is to vet your expert without telling him what the case is about, and the next is to talk about the case. But to the extent that the expert can learn about the case from the case materials rather than from you, that's a bonus. And finally, on this slide, encourage your expert to engage in a rigorous consideration of alternative hypotheses. I like to put in my reports, here's 3 reasons why this could have happened. And here's all the evidence for reason 1, here's all the evidence for reason 2, and here's all the evidence for reason 3. And at the end of the day, it's my opinion that it's reason 2 that's the most likely to explain it. But all the other hypotheses are on the table. They're all there to be discussed, to be cross-examined on. And the expert I've had the opportunity to say, I think it's 2 and here's why, and support my opinion, but making it clear that I've thought about all these other things. That's what makes for a credible expert. Okay, let's change topic. Let's see if we've got any questions. None so far.
Yeah, keep an eye.
So behavior genetics. We always think about genetics as nature versus nurture. But it's not that, in my view anyway. It's about nature and nurture together. How do nature and nurture interact to produce human behavior? And that's what behavior genetics is really all about, is the interaction of your genetic predispositions and your environmental experiences with nurturing, with nutrition, with environmental toxicity, with schooling, with how you're treated by other people in the world. According to a meta-analysis on data from 24 genetically informative studies, up to 50% of the total variance in aggressive behavior can be explained by genetic influences. And I cite there to the Tuvblad study. Understanding how genes and environment interact to produce violent and criminal behavior is the key. Having a genetic predisposition for criminal behavior alone generally does not determine the actions of an individual. However, the combination of a genetic predisposition and environmental risk factors does increase their chance for engaging in criminal or antisocial behavior. So what's the role for a forensic psychologist in this world of genes and wet lab studies? Well, forensic psychologists are particularly well equipped to look at, number 1, factors in an individual's history, appearance, interaction style, and an examination that may raise or refute the need to pursue genetic testing. In some of my cases, I've been the first point of contact to say, you know what? This guy doesn't look normal. He's got features that are suggestive of a particular disorder. Perhaps you should go out and take a look at that. The second thing that forensic psychologists are particularly well positioned to do is to evaluate the presence or absence of those environmental risk factors that can be triggers to let loose a genetic predisposition. We call this in fancy talk the diathesis stress model. That the diathesis is the genetic predisposition that you carry inside you, that your ancestors handed down to you, or that chance tweaked your genes in some way. to put you into the genetic position that you're in. The stress is then those events that occur in your environment that may cause that gene to be expressed or not expressed. Now, there are two genes that are particularly associated with violent repeat offenders. And these are the monoamine oxidase-A gene and a variant of the cadherin 13 gene. I'm not going to spend a whole lot of time giving you a lecture on genetics. Frankly, it's not my main area, although I have learned enough to be conversant about it. What I do want to talk about is a study by Tihonen and his colleagues in Finland that was published in 2015. It's at the bottom of the screen there, the paper. This is the first paper that's ever documented that criminal recidivism is associated with a specific pair of genes. The two genes are, as I said, MAOA and cadherin 13. Okay, there we go. So this is a particularly well-constructed study. Because of the way things are done in Finland, they do large population studies and collect data on the entire population, so there are great comparison groups. So what these researchers did is they took 800 criminals, 215 of which were nonviolent, and 538 of which were violent offenders, and then a subset of 84 of the violent offenders that had done at least 10 violent crimes in their history. So like psychopaths, the worst of the worst violent offenders. And they compared their genome to 2,124 normals from the community. And what they discovered, and it's kind of hard to see on this screen, the chart on the top kind of looks like the skyline of Manhattan. So that's all of chromosome 16. And the tallest building there, the Empire State Building on the right that has the blue box around it, they've kind of blown up in the slide below, but that's the cadherin 13 gene, that among these most worst of the worst individuals, they all had abnormalities on that gene. Now, MAOA is sometimes called the warrior gene. This is a gene that controls the amount of neurochemicals in your brain, dopamine and serotonin, that underlie a lot of human behavior. They're important for regulating aggression, emotion, and cognition. And it's particularly people who have low activity in MAOA that seem to be at increased risk for aggressive and antisocial behavior. Tihonen and his colleagues, based on this study, and not only did they do that one, but then they replicated it. They went out and found 5,000 more people from the community and another 114 violent criminals and duplicated the findings, giving them great confidence in saying that 5 to 10% of all severe, repetitive violent crime in Finland can be attributed to MAOA and cadherin 13 genotypes. Why is this important in capital litigation? Well, obviously, if your client or the defendant that you're prosecuting is in that 5 to 10%, this is going to be important mitigating information, particularly in concert with bad environmental effects. MAOA in particular has been shown to interact with child abuse, so that individuals who have the low MAOA activation gene and also experienced abuse as children are significantly more likely to have violent outcomes than those with the gene who were not abused. Some other examples of things that come up that I've seen in capital litigation, I mentioned in the introduction that I've done a fair amount of Atkins intellectual disability cases. And one thing that's come up repeatedly is individuals who are inbred, where their mother and their father were related in some way, whether they're cousins, whether the mother was raped by her own father, whether they're distant cousins. That type of inbreeding increases the risk for cognitive, behavioral, and intellectual impairments. So that's one thing to look at. Often this comes first from social history and family legend and stories that get told in the course of working up a case. But I've had several cases now where follow-up genetic testing has proven the degree of relationship between the parents, documenting the inbreeding, and the closer the inbreeding, the higher risk for bad cognitive outcomes. Another example are genetic diseases with forensic behavioral implications. For example, Klinefelter's syndrome increases criminality risk. Klinefelter's is sometimes called XXY syndrome. It's when men have an extra X chromosome. And what you see in these individuals, they tend to be tall and lanky, with no body hair, with strange teeth, with, we'll call them abnormalities of genital formation that make them smaller than normal. And often there are cognitive as well as behavioral implications of that syndrome. Recognizing those physical stigmata can then lead to genetic testing that helps to indicate the presence or absence of a disease like that, that ultimately has implications in a case because it increases risk for criminality. Another area that's been brought up for quite some time and largely dismissed by professional psychiatry around the world is the idea that my antidepressant made me do it. Zoloft made me do it. Prozac made me do it. However, even as evidence for that has, or opinions about that in the professional community have made it so that it's very difficult to find a psychiatrist who would support a position like that. New science is showing that, in fact, genetics help to tell that tale, that certain individuals have an increased genetic risk for experiencing negative side effects of SSRI medications that cause irritability, agitation, and anger. These often will occur early in the course when they're starting to take the medications. And there may be behavioral manifestations for that. That, in fact, if Zoloft didn't make me do it, Zoloft may have contributed to how I felt at the time and had a role to play in what happened. There's also hereditary transmission of risk for mental disorders, for substance abuse, and for violent behavior. So these are other areas in which behavior genetics, I think, is increasingly going to be coming into capital litigation, and increasingly we'll be looking at the science that underlies that as it evolves over time. It may evolve in directions that differ from popular perceptions at the moment as the science evolves. So my last topic today.
Before you get into your last topic, we actually did have a question come in that is actually relevant to your the first area you covered, and I think it's a very good question. So I want to take some time. I was hoping we could take some time for you to address it. And the question is around this issue of bias and biased decision making that all experts may be vulnerable to, just as a function of the human condition, and given the increasing attention this has had in the courts. There was, as you know, there was recently a study commissioned to look at expert testimony in the courts, and this issue was specifically identified as an area of concern. I think we have that reference in our reading list. So the question is, have you seen an increase in activity in questioning experts around this issue of bias and compromised decision-making around these various phenomena?
I have yet to experience it for myself, but I've got it on my radar to such a point that I'm extremely careful in using tools like the psychopathy checklist. I'm also very careful about trying to point fingers and call out the expert on the other side, saying, oh, these scores are too low, it must be cognitive bias. And what I think it's done at least from my practice, that I think is a good thing, is it's really forced me to be much more transparent than I might have been before in documenting the exact reason I gave every point on the test with evidence from the interview and from the records to make it as obvious as possible what I'm relying on to make these ratings in a way that can be verified and double-checked, as opposed to, because this is in some parts a bit of a subjective experience for the psychologist. You know, on any of 20 items on the psychopathy checklist, they can be rated 0 for not there at all, 1 for maybe there a little bit, and 2 for absolutely there, no question. And making those judgment calls is a subjective process that's vulnerable to bias. So to the extent that this issue is coming to play in court, what it's doing to me is forcing me to be much more careful and much more transparent in documenting, as I had said before, here's the score I gave and here's why I gave it.
You mentioned the psychopathy checklist in particular, your own personal experience, and then of course that actually was, you mentioned the results of a study that Dan Murray, Mark Boccaccini, and others had done. But there's no reason to think that this is something unique to the psychopathy checklist, right? That there are other kinds of tools, tests, or investigative techniques that mental health professionals might use that are just as, or maybe show the same kind of vulnerabilities, right?
Even IQ testing. There's judgment calls on whether an answer gets 2 points or 1 point or no points. So what I think this whole argument is going to do is just push us to be more explicit in explaining the basis for our opinions. And I think that's a good thing.
Okay, yeah.
Thank you. Great question. So I'll turn now. We've got about a half hour left. I'm sure I won't take all of that. So if you've got some questions in mind, start typing them so we can talk about them when I'm finished here. But the last part I'd like to talk about is forensic behavioral neuroscience. And as I mentioned at the outset, the idea of brain scans and neuropsychological testing in capital cases is nothing new. It's been around for 20 years, 30 years now that I've been doing it. But what I think is interesting is where the field is starting to evolve in terms of the science. And I want to talk about 2 studies that I think are illustrative of new issues that are emerging in this area. The first has to do with lesion studies of violent criminal brains. And here we're talking about a study of otherwise normal law-abiding people who had a brain injury and subsequently went and did a violent crime. So we'll talk about that. And then the other thing is looking at the brains of psychopaths and looking at brain regions associated with moral reasoning and the capacity for moral judgments. So these are the 2 topics we're going to be looking at. So the first study, this was published in the Proceedings of the National Academy of Science. This is a team of researchers from Harvard University and other places, but they're all affiliated with Harvard, led by Ryan Darby. And what they did, they looked at 17 cases of people who had no criminal history and then went out, got themselves a head injury, and subsequently did a violent crime. And what you see here are the brains of those 17 people, and the red areas are the areas where the brain damage occurred. And what the researchers were interested in looking at was whether there is a common substrate in terms of the functional neuroanatomy, where in the Swiss cheese the lesion lives, that could help to explain violent criminal behavior. So what they did, and the study's a lot more elaborate than we have time for today, but if you look at the pictures across the top, when they coalesce all of those brain lesions into one area, you see they fall in what's essentially, if you were looking down from the top, the frontal lobes and the temporal lobes of the brain. The slide next to it with the green shows areas where morality lives, where we've been able to look at moral judgments and where those occur. And then this picture at the far right shows the overlap, the areas where people who did violence had brain damage and those morality centers. And they correlate pretty well. What's interesting is that the areas that got damaged in these individuals encompassed areas where moral reasoning occurs. Now let's take a look at what happens with psychopaths. I mentioned Robert Hare and the psychopathy checklist. It's always been Dr. Hare's opinion that psychopaths' brains are wired differently, as he put it. And he's actually a co-author on this next study, which is about psychopathy as a disorder of the moral brain, and looking at frontotemporal-limbic gray matter reductions demonstrated by voxel-based morphometry. What the heck is that? So what they did is they looked at areas in psychopaths' brains where there's less brain material, less brain tissue, areas of atrophy or areas that never developed, and how those overlay with moral reasoning centers. These are scans that they obtained. And again, you'll see these are clustering in those same areas, frontal lobes and temporal lobes, in terms of where the volume reductions, where the amount of brain tissue is less in the individuals who have psychopathy than in normals. When you coalesce all those, you get these two little hot spots. The picture on the left is looking at the brain from underneath. So if I tilt my head back and you were to look at my brain from the underside, that's what we're looking at there. And the red spot is in the bottom of the frontal lobes. There's a famous case of a guy named Phineas Gage, which is where we first learned about frontal lobes. He was a railroad worker at the turn of the century out west. He was tamping some dynamite with a metal spike. The dynamite went off and the spike went through his chin, out through the top of his head, and right through that little red spot on the left. And what people noticed is this pleasant, mild-mannered gentleman suddenly became coarse, disinhibited, sexually preoccupied, swearing. His behavior changed. And that's because of a damage to that part of the frontal lobes. The other spot that you see on the right side is in the temporal lobe. And again, these are the two main candidate brain regions for violent behavior and atrophy. Now, what's the role of the neuropsychologist in all of this? So forensic neuropsychologists specialize in the study of relationships between brain damage and human behavior. We can put up scans all day long that show shrinkage or atrophy or damage or lesions in the brain, or abnormalities in the way the brain functions at a biochemical level. For example, PET scans that look at how the brain uses glucose as the gas that it burns to function. But at the end of the day, the brain scans are really silent about the person's behavior. A neurologist can intimate from where the lesion is, well, frontal lobes generally control this, but frontal lobes control a whole lot more than just violent behavior. Neuropsychologists are the people that medical doctors turn to in medical settings to understand the behavioral impacts of what they see on the brain scans. And that's nowhere more true than in criminal cases and capital cases. Neuropsychologists are uniquely situated to assess whether abnormalities seen in brain imaging studies have discernible cognitive, emotional, and behavioral manifestations that are relevant to the issues before the court. And neuropsychologists do this in a fashion that's not just my 20 years of clinical experience, but norms and data and real science that shows how this individual who's 60 years old and has 6 years of education compares to other 60-year-old men with 6 years of education in terms of the way his brain works. Finally, I'm going to close this on an interesting angle. And I've never seen this raised in a case, but I anticipate that it may be the direction that we see some mitigation going. And it's the notion, we've talked to this point about the overlap between brain impairment and moral reasoning, that the same areas that control morality are often the areas that are damaged or abnormal in people who do violent crimes. And what's interesting, historically, neuroscience defenses have been slippery slopes in front of juries. People say, well, if they're hardwired to be violent, what are we going to do? Because they're always going to be dangerous. How do we treat that? Well, this is the first place that I've seen a suggestion that there may be a way to treat that moral deficit in psychopathy. Notably, this is the same author, Ryan Darby from Harvard, on the first study that we looked at with the 17 brains. He's looking at using transcranial magnetic stimulation. It's sort of the same technology that they use in an MRI scan, where they use magnets to create micro vibrations and stimulate specific regions in the brain to enhance moral reasoning and moral ability, to treat deficits of moral functioning. Now, they're very clear to say you can't really see it because the slide's too small. At this point, this is baby science. This is a hot lead, but not a necessarily Daubert-worthy endeavor, because the same treatment may actually make some people worse. We haven't done enough of it to know how it works across a broad range of people. But this is the first paper that's begun to look at using non-invasive technologies to treat moral deficits, which may be the first inclination of a way to treat psychopathy, which has been elusive throughout all history and may remain so. But this is the hot lead, and this is what I wanted to share with you today. So with that, I think I end my talk, and thank you for your time.
We've had a few questions come in as you were finishing up your presentation, Dan, and I think they're relevant to a couple of the first topics you addressed. The first question, I'll lay it up for you, but I'll suggest that maybe the question is complicating some lexicon issues here.
Indeed.
But there's a question, one question is, are there any studies or correlations looking at associations between people described as psychopathic or psychopaths and sociopathic or sociopaths?
To me, these are terms for essentially the same thing. That sociopathy and psychopathy are essentially the same thing at their base. Psychologists have tended to use the term psychopath. Other professions, sociologists like sociopath. But at their base, at their root, we're really talking about the same universe of people, in my view.
Yeah. I don't think I disagree with that. I'd offer a couple responses, and again, it's hard to know where the questioner's coming from, but I was wondering if maybe the question was, are there any studies or correlations or any thoughts regarding distinctions between or associations with people described as psychopathic and having antisocial personality disorder? So that's one lexicon issue. My response would be that the overwhelming majority of people who are described as high in psychopathy, in terms of the characteristics of that impairment, those people largely meet diagnostic criteria for antisocial personality disorder. That is, they show a history of rule breaking and self-centeredness and law breaking and impulsivity that starts early in life and continues into adulthood. What I would say is there's plenty of people who meet the diagnostic criteria for antisocial personality disorder who are not necessarily psychopathic in nature. And I think the predictions are that in any prison population, you might get a prevalence of 75% of the individuals in males in prisons might meet diagnostic criteria for antisocial personality disorder, whereas maybe 25% of those same inmates might be described as high in psychopathy.
I think that's right.
Yeah. Next question is it beneficial to have both a neuropsychologist and a psychologist provide testimony in a particular case?
That's a great question, and I think it really turns on the nature of the case that you're working on. Randy had a great point at the beginning of this presentation that no psychologist can cover the waterfront. The field has become too broad, and you need people that specialize in specific problems. So to the extent that your case calls for it, it does make sense to have both a psychologist and a neuropsychologist to address different facets of a problem.
Let me ask you this. If there's an attorney involved in a case, can you provide some rules of thumb that might give the attorney some insight as to whether maybe this psychologist or the neuropsychologist might be most appropriate, or is there any kind of decision rules or case factors that an attorney might consider?
I'm always interested in knowing a little bit about the history of the individual, to the extent that there's an extensive history of head injuries, for example, or some medical condition that would involve brain functioning like a stroke, then clearly a neuropsychologist is going to be indicated. The complicating thing is that neuropsychologists are a subset of clinical psychologists. So we do everything the clinical psychologists do for the most part, and then do other things as well. So part of the issue is the presentation that you want to make to your jury. And there's one school of thought that thinks more experts is better. And I think that's generally true, especially if the experts follow the kind of guidelines that you laid out, that they're qualified, they're not biased, they've looked at all the angles, and they testify well. Then it's good to have more than one perspective. As to a clear history of substance abuse or psychiatric disorder, absent some neurological substrate, then I think a clinical psychologist is a good call.
And then it would obviously be if the clinical psychologist is hired, it'd be his or her responsibility to identify limits of expertise and maybe whether referral to or inclusion of a neuropsychologist is appropriate.
Exactly. I really like, in hospital settings, we do something called a treatment team, where you got experts in different disciplines that all come together to work on a case. And I think that's a great model for the law. It's not often employed. For one, it's expensive because you got to have a lot of experts. Number two, there's some perception occasionally, I hate to use the word collusion, but some suggestion, oh, you're all just teaming up to come to the same conclusion that helps the side that hired you. But I like to think it's really the best way. If I ran the world, we'd all be appointed by the court, independent of the parties, and we'd use a team approach. And I think you get to the truth with that most quickly. I understand we're an adversarial system and that's never going to happen. But I have to say, I'm always delighted when I'm either appointed by the court or appointed by agreement of both sides. That's a very good feeling for me, because it takes all that cognitive bias business out of the equation.
Okay.
Any other questions? I see we have one here. Whether we have any teachable moments from our most memorable cases.
I would say I don't want to talk about any one particular case, but what I will say is this: is that some of the most interesting cases that I've come across in the criminal realm has been with people with very extensive histories of mental illness. and trying to tease out when mental illness might be sort of occurring alongside maybe substance use or substance abuse. And also there's questions about kind of other factors and choices that an individual is making. And some of the most complicated cases are among the most interesting. And I know that's probably not satisfying to the questioner, but what I would say is that some of the most memorable cases, from my perspective as an examiner, have been where there's a variety of factors that are possible contributors to the behavior of interest, whether it's firing an attorney and representing yourself, or it's some kind of criminal behavior and criminal responsibility case, and trying to kind of tease out the many potential contributors: substance use, active symptoms of mental disorder, bad choices the person's making, the particular environmental or situational contingencies that are operating at the time. They're the most rewarding, for sure, and the most challenging as an examiner.
I think that's true. I think complicated cases are always more of a challenge than ones that are kind of straightforward and that you've done 100 times before. The important thing to me is, I always follow the same methodology, which is, to learn as much about the case as I can before I do the examination, so I have a grasp of the facts down to a level of detail around the instant offense where I understand what color shoes they were wearing and exactly what happened minute by minute as you go through the crime, so that when I get into the room and start to evaluate the person, that grasp of the facts helps me to gauge what I'm getting back from the defendant, the extent to which they're trying to fool me, or that they're being honest with me, to the extent to which they confabulate things that might not be part of the record, that may be a sign of some sort of neurocognitive problem, that they're making up things that actually never happened. To me, that part of my process of studying the case in as great a detail as possible before I go into the examination, if I was looking for a teachable moment, it would be that, because that's going to inform you. I know there's doctors who do just the opposite. They'll go in cold and do an exam with no preconceptions, no predisposition one way or the other, and then go look at the record. There's wisdom to that as well, in terms of trying to be objective and just seeing what you get. But the problem is, unless you schedule a follow-up examination, you don't have the opportunity to go back and confront and to test. And why do you tell me this? I know the shoes were blue. Why do you say they were red? Knowing a case in that level of detail, I think makes for a more effective examination. And it's hard to do unless you have the luxury of a big budget and a second evaluation. Well, I think we're almost up to the end of our time. Any other comments to close?
No, it's been a fun way to spend 2 hours with you. Yeah. I'm glad we had this opportunity. I hope those watching the webinar today, or by way of video recording, will contact us with any questions that you may have. And my understanding is we've have a reading list posted as well. But I've enjoyed it, and I know you have. And
absolutely.
I hope those of you who've been watching have enjoyed it as well.
So I have some closing things as the moderator that I need to share with you. First of all, thank you for joining us on today's webinar. Please continue to check the Spotlight section of our homepage on ncsstl.org, NCSTL, for information on upcoming webinars. All webinars are available on demand and can be found on the education and training page of our website. Please make sure to fill out the survey that you will be receiving by email. This survey will enable you to receive your CLE information. Contact our Office of Professional Education, OPE, at law.stetson.edu for further information or questions. On behalf of Stetson College of Law, the National Clearinghouse, the Bureau of Justice Assistance, and Dr. Otto and myself, thank you for attending.